Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 5 of our new series entitled QME Update 2023. And I have a great session for you, one of which I'm sure if you will follow the principles espoused in today's discussion, it will immediately improve your reputation as a qualified medical evaluator. And like all the other discussions in this series, if you follow the teaching principle of today's session, your reputation will greatly expand and your phone will begin to ring off the hook as the parties realize that you are part of the solution and not part of the problem. And I'll elaborate more on what is the problem that today's discussion addresses as we go. But before we get into the topics of today's material, let's just briefly review where we've come from so far in this program. Today we're in session 5, so these first 4 sessions have already been completed. Session number 1 was about causation, South Coast framing, and you as the QME. And I'll briefly provide the conclusions of that session here in just a moment. In session number 2, we talked about the presumptive injuries under Labor Code sections 3212 and 3213, which is a very important concept for you to understand, and especially for those of you who are evaluating our peace officers and our safety officers in the state of California, because the presumptive injuries and specifically the duty belt presumption is something that you're going to encounter with these particular classes of examinees. Session 3, we talked about the post-employment cumulative trauma injury claim, of which approximately 50 to 60% of all of your evaluations are going to involve a denied claim for an injured worker who is alleging a cumulative trauma injury, and that allegation is filed after separation of the employee from the employer. And we talked about how to handle that particular type of evaluation in session number 3. Session number 4, our last session, we talked about what the Division of Workers' Compensation has identified as common problems and common violations of the important labor codes and codes of regulation that govern and dictate the production of our final product, our QME report, that bears our signature and lives forever out in cyber land. And I shared with you some very simple suggestions that you can immediately install into your report that will dramatically improve the quality and the usability of your report for the parties. Now, today I want to talk to you about timelines in the QME evaluation. And this is a very important idea for you to review and remind yourself of your obligation as the reporting evaluator in the case. And that's the entire topic of today's discussion. In our final session coming up in 2 weeks from now, we're going to have next week off from all video productions, but in 2 weeks we're going to have an extra special session on depositions. And this is going to be a very, very valuable session for you. And I want everyone and the entire QME population to attend this session. In this session, we're going to have an applicant attorney and we're going to have a defense attorney. And these are not just regular applicant or defense attorneys. These are what are referred to in the industry, these guests that we're going to be having on session 6. These attorneys are referred to as hired guns in the industry. And that means that these attorneys are hired by defense law firms and applicant attorney law firms to conduct their depositions for them. These attorneys are hired as deposition experts, the so-called hired guns. And I don't know if you've ever been aware that you're being deposed by a so-called hired gun, but these hired guns exist out there, and they exist for the purpose of obtaining an outcome for their client. And these hired guns are going to share with us their secrets of success as to how they orchestrate a positive outcome for their clients by deposing you as the medical evaluator in the case. So this is an extra special session, and you'll be hearing a lot more about this over the next couple weeks. So stay tuned to your inbox for that. Okay, so let's just briefly review what we covered so far in sessions 1 through 4, and then we'll get on to the topics of today's discussion. In session 1 of our new program, we talked about South Coast framing, industrial causation, AOE, COE, and you as the qualified medical evaluator. And in this session, we reviewed the concept of liberal construction. And as we're going to see, the concept of liberal construction is a recurring theme throughout this entire series that we're discussing in this case of the new program QME Update 2023. And we introduced the concept of liberal construction in this South Coast framing case by reminding ourselves that the threshold for industrial causation is very, very low. Now, this is something that we've always known. We've heard of the so-called 1% rule bandied about within the industry. Well, South Coast framing reduced the threshold for industrial causation even below 1%. So in that sense, and in the spirit of South Coast framing, it seems that the applicants and the applicant attorneys have the cat by the tail, because in order to opine against industrial causation, and this has to do with your compensability evaluations under Labor Code 4060, the compensability evaluation, wherein you're called in to provide an opinion either for or against industrial injury. In these cases, if you're going to opine against industrial injury, you have to be able to successfully argue that 100% of the causes of the injury, of the causes of the need for medical treatment, of the causes of limitations of activity of daily living, of the causes of the disability are non-industrial. And this is going to be very, very difficult for you to do. So it seems, unless you can opine that absolutely no contribution arises from the workplace duties, it would seem that almost every single case that claims an industrial injury will get a positive thumbs up opinion on AOE COE for industrial causation. And that was part of the liberal construction on steroids concept promulgated by the South Coast framing case. In session number 2 of this program, we took the liberal construction concept a little bit further in our discussion about the presumptive injuries under Labor Code sections 3212 and 3213. And the presumptive injuries apply to certain classes of employees, namely the safety and police officers of the state of California. Safety and police officers. So for these certain classes of employees, when these certain classes of employees develop certain health conditions, and when certain circumstances are met, these conditions are presumed to be industrial, regardless of other contributors or other causes of those conditions. These are the presumptive injuries. The injuries are presumed to be industrial. So this is an extended application of the liberal construction concept to protect these certain classes of safety and peace officers here in the state of California. And the liberal construction extends even further for these examinees, these employees who go on to develop a permanent impairment. The apportionment of the permanent impairment is waived. 100% of the impairment is considered to be industrial for these certain classes of employees who develop certain conditions when certain circumstances are met. And this is another example of liberal construction as a theme that recurs throughout this particular program. In session number 3 of this program, we saw yet another application of the liberal construction concept as it relates to the so-called post-employment cumulative trauma injury claim. And we reviewed what is known about this particular species of claim, and it's amazing what actually is known. What's amazing is the numbers of facts, statistics, and patterns that have been discovered about this particular species of claim. And it's now known that the most common scenario involved with the post-employment cumulative trauma injury claim involves an injured worker in the manufacturing sector, the sector of manufacturing type of work. Among all the different sectors of work, manufacturing is the most common sector to claim an industrial injury and to file that claim post-employment. So the injured workers come from the manufacturing sector. They're primarily concentrated in the Los Angeles and San Diego County areas. And the most common diagnoses presented by these particular claimants involve the soft tissue disorders, especially and including carpal tunnel syndrome diagnoses. And we learned that it's two labor codes sections 3600 and labor code section 5412, that allow gobs and thousands, approximately 30,000 of these claims, to be filed and to survive every month here in the state of California. Well, there's some particular nuance about the date of injury under Labor Code Section 5412 that has allowed these claims to survive and to succeed. And we learned about the intersection of knowledge and disability as described in this particular labor code. But we reminded ourselves that the date of injury, as far as we're concerned as qualified medical evaluators, is not something that's especially relevant to us. And we're certainly not called upon to provide an opinion as to the date of injury in these claims. Rather, we as qualified medical evaluators are more involved with the period of time, the period of cumulative trauma exposure, which generally precedes by weeks, months, even years, and even decades, the date of injury in these cases. So the date of injury is not particularly relevant, except for us to understand how the concept of the date of injury is responsible for allowing these cases to come to us for our evaluation. And again, our responsibility in these cases is to opine on AOE. It's up to the trier of fact to make the COE determination. And then in our last session, session 4 of this new program, we talked about QME report violations. And we discovered what the Division of Workers' Compensation has determined to be the most common violations of labor codes and codes of regulation that QMEs are committing within the bodies of their reports, which collectively conspire to cause the report to be something that cannot be used in the resolution of disputed issues in our system here in the state of California. And we talked about how the state auditor's 2019 report explained that the Division of Workers' Compensation has failed to comply with state law to ensure that QMEs produce high-quality reports. Now, stated differently, you might say that the state auditor identified that what is circulating out among the thousands and thousands of reports that are being submitted by thousands of qualified medical evaluators, the majority and the main of those reports constitute low-quality reports. They're not high-quality reports, they're low-quality reports. And low-quality reports have a couple of unintended consequences and unintended impacts on the industry. Number one, low-quality reports, can delay injured workers' receipt of benefits. And this is not good. This is not a good thing. And we're going to talk in today's program about delay and what you can do to eliminate delay, at least in the areas where you have control. And then secondly, the second unintended consequence of low-quality reports is that low-quality reports add expenses for employers involved in these disputes. And here we're talking about the claims administrator. Now, many of you out there listening to this program might not be very concerned about the claims administrator's costs and what those costs may be and whether or not your evaluations and reports contribute to escalating costs for those parties. But I'm asking you to give some care, to give some consideration to the injured workers that are depending upon your report. and that are depending on you to provide conclusions within your report that can allow the case to move forward to a successful resolution, thereby eliminating delay in the system. And we're going to talk much more about delay in today's discussion, but for the purposes of our transition from this section in this session into our next session, I'm going to encourage you to do your part, to do what you can in your realm as the qualified medical evaluator to eliminate delays in injured workers' receipts of benefits. And that brings us to today's session. And in today's session, session number 5, I want to talk to you about timelines in the QME evaluation. And as you may or may not know, everything in this medical legal work that we do is governed by timelines. And all of the parties involved in the resolution of these cases, from us as the qualified medical evaluator, to the injured worker, to the claims administrator, all of the parties are governed by timelines. Now, let me ask you, what do you think the purpose of establishing timelines by law, and all of these timelines are described by law, and I'll share those laws with you here as we go. What would be the purpose of establishing timelines? Well, the purpose is to eliminate what we referred to earlier as delays. Without timelines, every party involved in the resolution of these cases and claims would introduce additional delay into the system. So timelines are intended to eliminate or at least reduce delays. And I want to share with you what you can do yourself as the qualified medical evaluator to expeditiously move these cases along to a successful resolution by eliminating the delay on your side of the court. Okay, and I want to tell you a story. I was recently at a QME continuing education seminar, and the audience in the seminar was approximately 50% medical evaluators and 50% attorneys, both applicant and defense attorneys. And we had a similar distribution of speakers at the seminar. We had attorneys, we had doctors, and the whole theme of the seminar, the entire 6-hour production, was about eliminating delay in the system, eliminating choke points that clog these cases up and prevent cases from successfully moving to a resolution. And I have on my desk, I want to share this with you, I have on my desk right now an exact case that demonstrates this principle. I have on my desk a case that I'm reviewing as a consultant that involves a denied claim where an injured worker was alleging an industrial injury. And the injured worker came to the qualified medical evaluation in April 2022. Now, this is being recorded in 2023. So the injured worker came to the QME evaluation in April 2022 for a compensability dispute, yes industrial injury or no industrial injury, from the qualified medical evaluator. Now, the qualified medical evaluator was unable to make the causation determination pending the results of some diagnostic studies. Well, the parties then undertook the process of obtaining the diagnostic studies, and the diagnostic study results were provided to the qualified medical evaluator in June of 2022. Well, somehow the request for supplemental report based on these new diagnostic studies got lost to follow-up and only resurfaced recently in February 2023. Now, that's a passage of time of 8 months. 8 months wherein an injured worker is waiting for a causation determination, waiting for medical care, waiting for benefits. And this is just an example of how delay and added unnecessary cost can be introduced into the system. And I want to share with you some ideas today as to how you can be part of the solution of eliminating these delays and allowing these cases to move towards a resolution under your direction. So today I want to talk to you about several timelines that are relevant to you as the qualified medical evaluator. I want to talk about timelines for the parties the timelines that face the parties when there is an objection that arises in any particular case or claim. And remember, it's the objection that calls for the need for the QME evaluation with you. So we'll talk about timelines for responding to objection, timelines to responding to the panel that becomes issued from the medical unit. We'll talk about timelines for scheduling appointments, timelines for notifying the parties of the appointment. And then finally, we're going to talk about timelines that govern the service of the report from your office to the parties. And the purpose of these timelines, and we'll talk about each one of these, the purpose of these timelines is to eliminate delay. Now, what we're going to see as we go through these timelines is that these timelines in and of themselves, if each one of these timelines are exactly met, in other words, if they're not exceeded, if they're exactly met, it still contributes to tremendous amount of time for the provision of benefits to the injured worker, and creates a tremendous cost to the system just through the accumulation of time. And I'm going to share with you how much time it can actually be before an employee suffers an industrial injury and the point in time when they can actually receive their first medical treatment. It's a period of months if all of these timelines run to their full extent, even without being exceeded. So I want to encourage you to do your part on your timelines, to expedite your timelines, to keep the system moving quickly. Okay? So with that as our introduction to today's discussion on timelines, let's talk about what happens when one or more of the parties claims an objection to some medical determination made by the primary treating physician. Okay, so let's begin. And in order to begin, I want you to imagine that in any particular injured worker allegation for industrial injury, or in any accepted injury, in any case, some objection has arisen. For example, there could be an objection from the injured worker to the primary treating physician's determination that the injured worker is now permanent and stationary. Or there could be an objection where the first evaluating physician has decided that there is no industrial injury. Or there could be some objection to the extent of the permanent impairment, or any objection that has arisen amongst the parties. It's this objection that sparks the need for a qualified medical evaluation with you for some type of medical determination. So let's divide our discussion among represented injured workers and unrepresented injured workers. And for unrepresented injured workers, this process is described in Labor Code section 4062.1. And it tells us that if either party, and this is unrepresented injured workers, so we're talking about the injured worker or the claims administrator, also known as the employer. If either party requests a medical evaluation pursuant to either of these sections, 4060, 4061, and 4062, which you need to be familiar with, either party may submit the form, and this is QME Form 105, requesting a panel of 3 qualified medical evaluators. Either party can do that. However, the employer may not submit the form, this is QME Form 105, unless the employee has not submitted the form within 10 days after the employer has furnished the form to the employee and requested the employee to submit the form. So the employee has 10 days, this is important. The employee has 10 days after receiving the form and after being requested by the employer to submit the form to the medical unit in Oakland to respond. If the employee does not respond within 10 days, then in order to eliminate delay, the employer then has the legal authority to take over control to keep this thing moving forward, and the employer then has the opportunity to submit the form on behalf of the employee. So this is the first delay eliminating law involved in the process. And it's very, very interesting because the party submitting the request, whether it be the employee or the employer, meaning the claims administrator, shall designate the specialty of the physician that will be assigned to the panel. So this is about control and eliminating delay. And in order for the employee to retain control over the physician on the panel, the employee must submit the form timely. Timely meaning within 10 days. If the employee does not submit the form within 10 days, control for eliminating delay and control over the physician gets transferred over to the employer, and the employer then has control over selecting the physician. So it's very, very interesting. In order to retain control, the employee must respond within a certain period of time, and the employee must not introduce delay into the system. This is the first delay eliminating legality involved in the entire medical evaluation. Okay, so what other delay eliminating requirements does the law impose on the process? Well, 4062.1 Section C says that now, after one of the parties has requested a panel to be issued, within 10 days of the issuance of the panel, the employee has first crack at it. The employee shall select a physician from the panel, and the employee shall schedule, so that's two verbs, shall select a physician and shall schedule the appointment. And then the third verb is the employee shall inform the employer of the selection and the appointment. So again, the obligation, the initial obligation is on the employee, but you can think of this as not so much an obligation as more of control. The employee has initial control, and this is again another circumstance or instance of our liberal construction philosophy that recurs as a theme throughout all of the workers' compensation laws, including 4062.1. Now, if the employee does not inform the employer of the selection within 10 days, so now we're at 20 days. Okay, so we had 10 days for one party to request a panel. Now we have 10 days to select a physician from the panel. We're now at 20 days. And if you consider that there's a few days in the beginning to ramp up this procedure and get the form, QME Form 105 distributed to the employee, we could be now at 25 days from the date of injury. So if the employee does not inform the employer of the selection within 10 days of the assignment of the panel, then the employer may then regain or take over control, and the employer may then select the physician. And this is the opportunity again for the employer to eliminate delay and to control the movement of this case along its life cycle. Because if the employee drags their heels and does not select a physician for whatever reason and for whatever motive, the employer can step in and exercise the right to select the physician. Finally, if the employee does inform the employer of the selection within 10 days of the assignment of the panel but has not made the appointment, thereby again introducing delay. Okay, the employee has made the selection, has exercised their control over the physician selected from the panel, but for whatever reasons drags their heels on making the appointment, then the employer may then make the appointment. So again, this is the oversight of the employer to eliminate delay, to keep the process moving along, and to create some end in sight for these injured workers and for these in these cases that involve some form of an objection. So let's take a look at this process now in visual form. So let's take a look at some of these timelines now in visual format. So here at the beginning of time over here, the employee has 10 days control over the specialty of the panel being selected, the specialty of the evaluator being chosen. Now, if the employee does not exercise their control over the specialty, then the employer here gains control of the specialty of the physician to perform the evaluation. After the specialty of physician is selected and the panel is issued, control then goes back to the employee, and the employee has 10 days control over the selection of the specific evaluator from the panel. Again, however, if the employee does not exercise their control, then the employer gains control of the selection of the doctor from the 3-doctor panel. So in a timeline form, this entire timeline here could be a 20-day timeline, 20 days. And if you consider that back here at this point in time, back at an inception, there could be a several-day ramp-up period of time here just to get the employee the QME Form 105, and just to get the employee a letter from the claims administrator regarding the objection, etc. This whole process could be as much as 30 days. Now imagine you're an injured worker with an actual bona fide injury. This 30 days could be devastating to your health. So it's important for us as qualified medical evaluators, despite these timelines, to do what we can to help expedite the process and not further contribute to the problem by introducing unnecessary delay. So in timeline form, the employee has 10 days to request the panel. If the employee fails to exercise their control and fails to comply with the timeline, then control over the panel and the panel specialty switches to the claims administrator, and the claims administrator then takes control for the forward movement of this claim towards a resolution. And then the employee regains control and has 10 days to select a physician. If the employee fails to exercise that control and the employee introduces more than 10 days delay into that process, then control switches back to the claims administrator. And this is very elegant control switch, control eliminating delay, all of which has as its intention to keep claims moving toward a resolution. And I'm telling you as a qualified medical evaluator that if you can help the system by helping to successfully move these cases to a resolution, your phone will ring off the hook and you'll have more evaluations than you can possibly handle. Now, for represented injured workers, the process is much the same with only a couple of subtle nuances of difference. So for represented injured workers, the process is described under section 4062.2. Unrepresented injured workers was 4062.1. So this section tells us that no earlier than the first working day, that is at least 10 days, okay, so we have a 10-day time period, after the date of mailing of a request for a medical evaluation, pursuant again to the same code sections, 4060, 4061, 4062, either party may request the assignment of a 3-member panel of QME doctors to conduct the qualified medical evaluation. So there's a waiting period here of 10 days. Now, this is a mandatory delay. This 10-day time period cannot be shortened. And of course, each party wants to shorten it. But the law says no earlier than the first working day. That section and that statement, that language, is what prevents one or the other parties from jumping the gun and trying to exercise control over the panel process. So all of the parties must wait at least 10 days. So there is our first period of delay introduced into the system for this poor injured worker. Now, similar to the situation for an unrepresented injured worker, we now see the introduction of our second 10-day time period of delay. It says that now that either party, after 10 days waiting, may request the issuance of a panel. Now, once the panel is issued, within 10 days of the assignment of the panel, each party may strike one name from the panel, and the remaining name on the panel shall serve as the medical evaluator. Now, this is important for you to understand because this is what's going to bring you many, many cases, and this is what's going to get your phone ringing as one party tells you that you are the last doctor standing after the strike process. Now, it gets even more interesting. It says that if one party fails to exercise the right to strike a name from the panel within 10 days, then what happens? Then, similar to the process with an unrepresented injured worker, the control shifts to the party it shifts away from the party who's introducing the delay. In this case, the party who fails to respond to the panel. It says that the other party may then select any physician who remains on the panel. And again, this is a legal requirement that has as its net intended consequence to keep these claims moving forward. Any sleepy party who is lazy and fails to respond to the panel loses their input over the selection of the physician, and the other party regains control, and that regaining of control is what allows the claim to continue moving forward. Finally, it says the represented employee shall be responsible for arranging the appointment for the examination, and this is why you get so many calls from applicant attorney's office who are acting as an agent of the represented employee and are complying with the law and are thereby going ahead and scheduling the appointment. However, if the represented employee has made their selection and has even selected the evaluator that remains on the panel, but upon his or her failure to inform the employer of the appointment within 10 days after the evaluator has been selected, the employer may then arrange the appointment. So you see we have these introductions of successive 10 days, 10 days, and 10 days, and we're now up to 30 days. The accumulation of all of these delays, we're now up to 30 days delay after the date of injury for a represented injured worker. So let's take a look at how this looks in visual format. I'm sorry, I meant to say that the accumulation of timelines up to this point in time is now 20 days. So let's take a look at this. So in the beginning, when some objection has been registered, either party, whether that be the employee or the employer, has 10 days to exercise their strike of a physician from the panel. Now, what you're going to see in the typical scenario that you're going to see is that one or the other parties does not respond to the panel. And typically, it's the defense attorney that does not respond to the panel. And the applicant attorney is just waiting for that 10th day, such that he or she, meaning the applicant attorney, can regain or gain control of the forward movement of the claim. And it's the responding party that gains control of the physician by being able to then strike a second name from the panel, thereby leaving one doctor as the last doctor remaining on the panel, and that becomes the physician evaluator involved in the evaluation. From that point forward, the parties, in this case, in the example that I'm citing to you, where it's the applicant attorney or the employee that gains control of the physician, they have 10 days to schedule that appointment. 10 days. Now, if the employee or the applicant attorney does not schedule the appointment within 10 days of the selection of the physician to do the evaluation, okay, then the employer can then gain control of the scheduling of the appointment. And so in timeline form, it looks like this. In the beginning, the injured worker and the other party, the claims administrator, both have the opportunity to control the process moving forward, and they each have a 10-day period in which to exercise their right to strike a doctor from the panel. If one or the other parties fails to keep the claim moving forward, control for moving the claim forward switches to the other party. The other party then may exercise control over the physician who performs the evaluation. At that point, that particular party with the control has 10 days to schedule the appointment, but in the event of failing to comply with the timeline, control switches to the other party. And in this sense, this oscillating of control from party to party is what allows this case to successfully move forward, to the extent that it's governed by these lengthy timelines for each one of these processes. Now we're going to get into your side of the court, your side of the coin, and talk about the timelines that govern the work that you do. And I want to share with you some ideas as to how you can, on your side of the court, keep this case moving to a successful resolution. Okay, so the parties have finally selected a physician to perform the evaluation. Control has switched back and forth, and finally, your phone rings with one or the other parties calling you to request a qualified medical evaluation. This is where the timelines and the responsibility for complying with timelines shifts to you, and that begins with the appointment notification form. And we'll talk about the scheduling of the employee or injured worker here in just a minute, but part of the scheduling procedure involves you completing the appointment notification form. This is where your first timeline becomes operative. It says that, and this is right off of the appointment notification form, it says that you as the QME must serve the appointment notification form on the employee and the claims administrator, or the employer and their attorneys, if within 5 business days after having scheduled the injured worker to be seen for a QME evaluation with you. Now, this is your first opportunity to condense the timelines and to condense the time involved, condense the waiting period that this injured worker must wait prior to receiving a determination from you. So I'm encouraging you at this point to jump on this appointment when this appointment comes in and condense this 5-day time period. Condense it to 4, condense it to 3, condense it to 2. Now, all of us know that getting a case scheduled is a big process. It's a big deal. And it does take time, and there's a lot of administrative details that can take a day. It can take 2 days, and we all know this. But I'm encouraging you to do what you can to compress this time period down to the minimum possible. And I'm certain that you can get this average down to about 2.5 days, which is 1/2 the time allocated. You can get this down to about 1/2 of the time allocated if you give it your best effort and your due diligence to get it done within 2.5 days. So that's the appointment notification form. Where else can you, as the qualified medical evaluator, compress the timelines? Well, your greatest opportunity for compressing the timelines has to do with the time period within which you schedule the appointment. So let's see what the law says. The law says if a party with the legal right to schedule an appointment with the QME, so in this case, this could be the employee who retains the legal right, it could be the claims administrator, it could be one or the other of those or their agents. If that party is unable to obtain an appointment with a selected QME within 60 days, the party may waive the right to a replacement panel in order to accept an appointment no more than 90 days. Okay, so imagine this. You receive a phone call for an appointment and you're not available until 65 days from the date of the appointment call. Now, that party can have you replaced and can obtain a replacement panel because you're not available within 60 days. Within 60 days, they have the right to a replacement panel if you're not available within 60 days. So always be available in less than 60 days. Now, that party can waive the right to a replacement panel to accept an appointment up to 90 days. This is the party who's calling and scheduling the appointment. They have the authority to accept an appointment up to 90 days if they so choose. If they do not choose to wait beyond 60 days, they can have a replacement panel issued, okay? So you want to always be available within 60 days. And you all get these calls from attorneys' offices asking, when is Dr. Smith's next appointment in Los Angeles? And the answer is the doctor is available within 60 days. Thereby, you as the evaluator retain control of that evaluation. Then it says when the selected QME is unable to schedule the evaluation within 90 days. Okay, so the party has waived their right to a replacement panel. They're now going to wait up to 90 days. Either party may report the unavailability of the QME, and the medical director shall issue a replacement unless both parties agree in writing to waive the 90-day time limit for scheduling an initial or even any subsequent follow-up reevaluation. So going beyond 90 days requires written agreement from both parties. So always avoid these problems and compress the timeline. Keep the case moving forward by allowing yourself to be available within the 60-day timeline wherein there is no way that the parties can have you replaced as the evaluator assigned to this particular evaluation. Now, this 60 and 90-day timeline requirement has just recently been changed. And for some of you, this is going to be good news, but I have some words of wisdom and some cautions regarding this new flexibility that just passed and became effective February 2nd, 2023. Now, the same language of the law replaces 60 days here with 90 days and replaces 90 days with 120 days. So we have now an increased 30-day delay flexibility in the scheduling of these appointments. So let's read this passage. It says, again, if a party with the legal right to schedule an appointment with a QME is unable to obtain an appointment within 90 days of the date of the appointment request, then that party may waive the right to a replacement panel in order to accept an appointment no more than 120 days after the date of the initial request for an appointment. So now, when you get a phone call asking, when is Dr. Smith available in Los Angeles, your reply should be within 90 days. That way you retain control of the case as the qualified medical evaluator. But I'm encouraging you to stick with the prior 60-day maximum. Schedule these appointments as soon as possible such that you exercise your authority and your dominion over the claim, and you keep the claim moving forward, and you as the qualified medical evaluator remain part of the solution of bringing these claims to a resolution versus being part of the problem and simply extending your own timelines another 30 days because the law allows that. You do not have to accept this or comply with this. You can still schedule the appointment within 4 weeks, 5 weeks, 6 weeks, 7 weeks, 8 weeks, which is 60 days of the date of the initial appointment request. You can still schedule the appointment earlier rather than later. And then again, the same change in language from 60 to 90 and 90 to 120 says when the selected QME is unable to schedule the appointment now within 120 days of the date of that party's initial request, either party may report the unavailability of the QME, and the medical director shall issue a replacement unless both parties agree in writing to waive the 120-day time limit for scheduling the initial or any follow-up evaluation. And I'm asking you to get this done in less than 60 and certainly no more than 90 days. Because remember, there are injured workers on the other side of these evaluations. And we've already seen, even before the phone call comes to us, 20 to 30 day delays from the date of injury, and then an additional 5 days for the appointment notification form to go out, and now up to 60 and 120 days. We're now looking at 5 to 6 months before your report is issued from the actual date of injury. Can you imagine such a system? So I'm begging you to do what you can to expedite your timelines. Okay, so the evaluation has been scheduled, the evaluation has been completed. Let's now talk about report submission guidelines. And report submission guidelines and the timelines for submitting your reports are very clearly defined in at least 3 laws. Labor Code sections 139.2, 4062.5, and then CCR 38. And we're going to talk about CCR 38 here word for word as it's written into law. Now, I want to encourage you, before we go through this section of the law, I want to encourage you as the qualified medical evaluator to expedite the report submission process on your end. This is something over which you have complete control without oversight from any of the parties involved in the claim. This is something that you control completely. Now, I remember we had a momentary extension of the timeline for submission of the QME report under the COVID emergency regulations, where the regulations allowed for an additional 15 days flexibility. In other words, up to 45 days to submit our written report. And I had one consultation client that would routinely call me for a consultation on the 44th day after the face-to-face evaluation. And I continued to ask this evaluator, why are you waiting to the 44th day? This is something that you could have completed weeks ago. Why are we at the 44th day? And it seems that this is simply an application of Parkinson's law, which says that all jobs expand to fill the timeline allocated for the job. So I'm asking you to pretend or imagine that the timeline is 2 weeks, 14 days. If the timeline is condensed to 14 days and you were required by law or under threat of serious bodily harm to complete the report in 14 days, you could get the report done in 14 days. In fact, you can get the report done in 4 days. So I'm asking you to compress the timelines. Now, the COVID emergency regulations have been relieved, and we're no longer under that 15-day extended flexibility, and the timelines are still unchanged by law. And the law says that the time frame for an initial or a follow-up comprehensive medical legal evaluation report to be prepared and submitted shall not exceed 30 days. Now, this 30 days brings us to a fully 6 months after the date of injury. After the QME or the AME has seen the employee or otherwise commenced the comprehensive medical legal evaluation. So there's no reason that these reports should take you 29 or even 30 days. If you get serious about these reports, you can complete these reports the very next day after the evaluation. And let me tell you, if you can complete the report within a day, 2 days, 3 days, 5 days, 7 days, if you can complete the report quickly, your reputation will immediately expand in the industry because the parties have one intention and one intent, and that is to move these claims toward a resolution. And if you can participate in that, you will get more evaluations than you can possibly handle. So this is a practice building and success building and wealth building secret for you. Complete your evaluations quickly and at least on your side of the court for what you have control of. If you can condense the timelines, you will be a friend of the system and a friend of the parties, and the parties will use you, and you will enjoy a long and successful career in this medical legal work that we do. So doctors, I hope this helps you. I want you to take a moment and just imagine that you are an injured worker in the workers' compensation system in the state of California, and you have a date of injury today. And for whatever reason, some dispute arises in the system, and you find yourself thrust within the qualified medical evaluator process. Can you imagine that from the date of injury, it could be 6 months, 6 months, 6 full months between the date of injury and the time you receive a determination from the qualified medical evaluator. Now, as an injured worker, a small fraction of those timelines are under your control. Much of those timelines are under the qualified medical evaluator's control. So imagine that you're an injured worker. You would be waiting and waiting and waiting, and your family would be stressed and anxious and waiting for the qualified medical evaluator's determination. First, they'd be waiting for you to schedule an appointment within a reasonable time frame. Then they would be waiting for you to submit your report, hopefully within 30 days and hopefully much less than 30 days, so that the injured worker could get some resolution to their problem. And these injured workers and the parties as a group look to us as qualified medical evaluators to do our part to help move these cases along. So I'm encouraging you to exercise control over the domain that you have control over and compress your timelines from the initial appointment call and submission of the appointment notification form to the scheduling of the appointment much less than 60 days when you can, and certainly to the submission of your report either the next day after the evaluation, 2 days after the evaluation, within a week after the evaluation. But strive to sequentially reduce the timelines involved in all of the steps that you're involved with to help bring these cases to a successful resolution. So I want to thank you for taking the time to join me on today's discussion. I want to thank you for your commitment to excellence in the work that we do. I want to thank you for your dedication in helping to resolve disputed issues in California workers' compensation. And I want to thank you for taking the extra time, the extra effort, and putting in the extra energy to go the extra mile in the service of California's injured workers. For now, this is Dr. Perry Carpenter wishing you best of success in your career as a qualified medical evaluator.